Hello, and welcome to today's National 8A Association February 2023 webinar. I'm Haley Bingham, Deputy Director with the National 8A Association. The National 8A Association is a nonprofit with a mission to provide education and guidance for all aspiring, current, and graduate AAs. We are also proud to work with all types of minority and small businesses, HubZone, veteran-owned, women-owned, JVs, agencies, large primes, and industry professionals. Before we begin, I'd like to note that this webinar is being recorded and all presentation materials will be posted on our website. If you'd like to ask any questions, please use the chat box and select everyone or email us at events@national8aassociation.org. I'd now like to introduce you to today's speakers, Christopher Slotty and Jean Back with Schwabe, Williamson Wyatt. Please join me in welcoming our speakers as they talk to us more about the Federal Trade Commission's new proposed rule barring non-compete agreements and what it means for your small business. Welcome, Chris and Jean.
Thank you.
Thank you, Haley. This is Chris Slotty. Again, as Haley said, we're with Schwabe. I'm with Schwabe, Williamson Wyatt. I'm based out of Anchorage, Alaska. I work with a lot of Native corporations, but also with a focus on government contracting, including the Small Business Administration programs and the 8A program.
And I'm Jean Back. I work with Schwabe out of the Portland office. I work with Chris helping Alaska Native corporations and small businesses. I'm an employment lawyer, so mostly that is where I fit into the picture.
So today we're going to be talking about the Federal Trade Commission's proposed ban on non-competes. And to start off with, here's a quick summary. So the Federal Trade Commission has proposed a very broad ban on non-compete agreements. The proposed ban would apply to all post-employment non-compete restrictions, regardless of position. Therefore, it would apply to both, minimum wage workers, but all the way up to the C-suite, CEOs, COOs, etc. The proposed ban would also include agreements or restrictions that would effectively prevent employment in the field, such as, in the FTC's view, overly restricted NDAs and non-solicitation agreements. The only exception the FTCA has currently proposed for this broad ban on non-competes is those related to the sale of a business. In the proposed rule, the FTC did state that it is considering alternatives, including potentially adopting a presumption that non-compete agreements are non-enforceable versus just a ban, or limiting the application of the ban to those employees based on job function, compensation, or other factors. And the current deadline for comments on the proposed regulations, the proposed ban, is March 20th, 2023. And so we're going to address all these different issues and a few other ones during the course of this presentation. So why is the FTC proposing a ban on non-competes? Well, the FTC has adopted essentially two reasons for why it believes that non-compete agreements should be banned as an unfair trade practice. The first is that non-compete agreements are unfair because they depress wages by limiting competition for employees. And here I have a quote from the proposed rule. From the FTC's perspective, non-compete agreements prevent employees from easily transferring jobs and therefore restrict their ability to maximize their earning potential by limiting the choices in which they can go, choices of employers in which they can go to. Therefore, kind of limiting the ability or enhancing the ability of employers to keep them without having to increase their wages or provide other benefits. The other reason why the FTC is proposing a ban is that the FTC argues that the non-compete agreements are unfair because they reduce innovation by restricting movement of employees. Essentially, they try to rely on studies saying that as there's greater kind of movement of employees between companies, that increases innovation, increases entrepreneurship, and that the restriction on and non-compete agreements will restrict the restriction on the ability of employees to move will decrease that innovation, decrease that entrepreneurship by requiring employees to stay with one single employer for longer periods of time. What is the legal basis for the FTC's proposed ban? It is relying on Section 5 of the Federal Trade Commission Act, which provides that unfair methods of competition in or affecting commerce are unlawful, and also authorize the FTC to prevent persons, partnerships, or corporations from using unfair methods of competition. So essentially, they're saying that they're going to define a non-compete agreement as an unfair method of competition by regulation, and then that would give them the legal authority to bar non-compete agreements and to take action against employers that try to enforce non-compete agreements that are now, under the proposed rule, defined as an unfair method of competition.
This one, Chris?
Yes.
Okay. They don't have the slides numbered. So which employers would the ban apply to? Basically everyone. There's no limitation for small businesses. So we're all in the soup with this ban. And which employees would the ban apply to? Really all employees as well. There's no exceptions based on salary. And that's something that maybe we can expect as in the future if there's enough basically pushback on this, we may expect the FTC to come back and, as Chris mentioned earlier, give some sort of limitation, like it only applies to people who have salaries of $100,000 or more, or something similar to what some states such as Oregon and Washington have done. But right now, that's not what the ban proposes. It's a complete ban. And the FTC is soliciting comments. So, if there are things that you might think will help, to maybe if the ban does go through, but it would help maybe small employers if it only applied to certain employees, then that's something that we could propose through comments. What would be banned? Essentially a contractual term, such as one where you have an employee sign an employment agreement that has a non-competition provision, or as many of my clients do, have employees sign at the very beginning of employment or upon promotion to a job, a document that is a non-disclosure, non-solicitation, non-competition agreement. So any sort of contractual agreement with your employee that contains a non-competition agreement. It applies to post-employment restrictions regardless of length or scope. So right now, there are some states that say, oh, you can have a non-competition agreement as long as it only is for 12 months or some period of time like that. Here, there's no such limitation. It's, as we've said, all agreements. Going. And what type of NDA or agreement would be banned? So a non-disclosure agreement between an employer and a worker. So this happens in Oregon where I practice a lot. If a lot of times the non-competition or non-solicitation and non-disclosure agreements are so broad that they actually are a non-competition agreement, that they actually prevent the employee from being able to go out and set up their own shop or work for another employer. So that's the kind of, in addition to just a regular non-competition agreement, this ban would also include overbroad NDAs and NSAs. Also, and this is one that is, I think, particularly hard for a lot of employers, it would ban those types of agreements where you've entered into an agreement with an employee to provide an education. And part of that agreement is that they will work for you for a period of time. So you pay for their college degree and they say they'll work for you for 3 years. And if they leave before the 3 years is up, then they'll pay you some amount of money. Those types of agreements would be banned as a restriction on the employee being able to leave employment. Essentially, there's going to be a fact-specific inquiry on that and no specific standards for determining what payments are reasonable related to the costs that the employer incurred. So that's a pretty hard one to swallow, actually. Okay, so for a summary, the ban is going to be, cover all non-competes. It's going to cover terms that effectively prevent an employee from working for a competitor in the field, and terms that require an employee to pay the employer back for training or expenses, and the amount required to be paid is excessive in comparison to the cost of the training. And again, also, it's going to cover any NDAs or NSAs that are written in such a way that are over broad.
I think, as Jean said, the proposed FTCA ban is very broad and applies to really any post-employment restriction on post-employment restriction. The one exception that they have given, that the FTC has included in the proposed rule, is for non-compete agreements entered into in connection with the sale of a business, which they define as the sale of 25% or more of the ownership interest in a business. So if you are acquiring a government contractor or you are selling as part of that acquisition/sale, you could either be subject to or agree to, or have the selling party be subject to a non-competition agreement, the validity of which would just be governed by applicable state law, and the FTCA ban would not apply to those non-competes, again, executed though only in connection with the sale of 25% or more of an ownership interest. So it's a pretty limited exception, a necessary exception, but again, very limited. So one question that we've gotten is, what happens to your existing non-compete agreements, right? Because a lot of folks will already have non-competes. Well, under the FTCA rule, there are existing non-compete agreements are not grandfathered in. Rather, employers will have to rescind non-compete agreements or those terms that are barred by the proposed rule. This would include giving notice to current employees who may be subject to perhaps an employment agreement that contains a non-compete clause, and to former employees who have already left that are currently subject to a non-compete clause. So, for example, you may have an executive that you signed up for an employment contract. You would have to go to them if this FTCA rule is enacted as drafted, and give them notice and saying, yeah, hey, yes, I know we negotiated and signed an employment contract, and a material term of which was this non-compete agreement that was going to apply if you left employment, but that term is now no longer valid. And then for your former employees who are currently subject to non-compete, you are going to have to reach out to them and provide them notice and releasing them essentially of the restrictions currently imposed on them by their existing non-compete agreement.
And Chris, I want to mention just here, for those states that have state laws that impact non-compete agreements but allow them in certain circumstances, Chris, is your feeling that this law is going to essentially supersede those state laws, that they'll have to comply with the federal law and the state laws will then become ineffective?
Yes, the FTC rule actually specifically states that it will supersede any state law that is less protective of the employee's right to seek employment after post-employment. So yes, this would seek to basically, it would render those state laws that permit non-competes in certain circumstances irrelevant, because all non-competes would be banned under the FTC rule. As that was my next slide. Sorry.
Sorry about that.
So the idea is basically that unless the state law provides employees with greater protection than that provided under the rule, the FTC rule would supersede that state law. Given that the FTC's current rule is a complete ban, there really would be no state law that necessarily would provide greater protection to employees. So this would control over any contrary state law. So the FTC rule is pretty basic, essentially, as it's been drafted in terms of the actual rule, the language of the rule. It just says non-compete agreements, restrictions on post-employment are banned as an unfair trade practice. So that in and of itself raises a lot of questions. And one of the most significant one is, what about severance agreements, right? In many cases, when you have a senior executive or a senior employee leaving and you enter into a severance agreement with them, either as part of their original employment agreement or in a post-termination settlement or resolution, oftentimes you will say, all right, I will pay you X number of months of salary as a severance, and in exchange for that, or as part of the exchange for that, you will ask for that they agree to a non-compete clause for that same period of time. So if I'm paying someone 6 months of severance, I will generally ask for a 6-month non-compete clause. Under the proposed rule, you could not do that. That non-compete clause, even if agreed to or entered into in conjunction with a severance agreement, would be illegal and invalid. And what the FTC has not considered, and it certainly has not addressed in its proposed rule, is what about those severance agreements you've already entered into that are either you're already paying a severance or it's already part of an employment contract in which, as a material kind of exchange, in exchange for agreeing to give the employee a severance, what you are getting from the employee is the agreement to not compete. Under the proposed rule, the employee's side of that deal, the agreement not to compete, would no longer be valid, and they could go and compete with you. So I think this is a significant issue that FTC needs to consider and to address, because it's really kind of removing a material part of the consideration that employers receive for agreeing to enter into a severance agreements. And again, what about severance agreements with non-compete clauses that were entered into prior to the adoption of the rule? Well, the rule, again, does not provide any grandfather clause. So all those severance agreements with a non-compete clause, the non-compete portion of it would now be invalid, raising significant questions as to both, is the rest of the agreement enforceable now? Does the employer get to stop paying the severance because they're not getting what they contracted for? Or are they just going to have to essentially lose part of the consideration that they negotiated for when they agreed to pay the severance?
And also, what about what standards are going to apply to decide what training costs must be paid or what's reasonably related? I mean, we're assuming if this rule goes through, there'll be some other sort of follow-up rules that will probably address some of these things. But what are the reasonably related costs incurred by the employer in paying for an employee's training or education costs? Right now, there's nothing specific that we can point to or provide you with any guidance on that. Also, we don't know what standards will apply to determine if a clause prevents the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. So how are they going to establish that a clause actually does that? And especially, I think, non-compete clauses specifically usually say you can't go to work for another employer in this industry, or you can't, hang out your own shingle and start your own business. However, I think this applies to the question of these overbroad NDA and NSA provisions. How are we going to know whether this actually prevents a worker from seeking or accepting employment when really you're just asking them not to solicit your clients when they leave your employment? I have seen in my state where I practice, Oregon and Washington, there are cases that have been decided under the non-compete statute that we have, where they've said that non-solicitation provisions are overbroad. So there is, a reason for them thinking that, but still, it would be nice to have some indication when drafting these provisions to know what we can say and what we can't say. There's just no specific rules. Also, what alternatives to a broad ban is the FTC considering? Right now, we don't know that. There could be adoption of a rebuttable presumption instead of a categorical ban, but again, that means you still have to rebut a presumption. The FTC has given us some information about that. They say under this approach, it would be presumptively unlawful for an employer to use a non-compete clause, but the use of a non-compete clause would be permitted if the employer could meet certain evidentiary burden based on a standard that would be articulated in the rule.
Which is exceedingly vague, right? We have no idea what the standard and it would almost inevitably lead to just more litigation as the parties, the employers and ex-employees try to litigate to figure out the actual contours of what would be this presumption, what would be the standards. So it's gonna end up with a significant burden on employers and employees, frankly, if they end up having to fight about this.
Usually when that happens, in my experience, because I've practiced a lot in the non-compete enforcement arena, the employee doesn't have the funds usually to litigate those kinds of cases. So sometimes that's beneficial to the employer if the employer has the funds to litigate, but they're very expensive cases. There's no way around it. They're not insured, and it's just an outlay of money for litigation expenses. So the also one thing that question we have is what alternative to the broad ban is the FTC considering? So we've talked about adoption of the rebuttable presumption of unlawfulness. But there could be a rebuttable presumption of unlawfulness to non-compete clauses and I kind of mentioned this at the earlier, for employees earning less than 100,000, they may rely on state statutes that are already in effect. There are several ways that states are trying to regulate this. Both Oregon and Washington put a monetary amount, and it's kind of in the $100,000 range. You have to be earning that in order to be able to have a non-compete. I believe in Idaho, you have to be a key employee, and that's one of the top 5% of the earners in the business in order to have a non-compete. So different states already have these different kind of limitations to being able to have a non-compete. And so that is, something that the FTC could look to as sort of examples of how to basically allow employers to have non-competes for their very, very, very high wage earners.
And another example of that, and this was something identified specifically in the proposed rule as a potential alternative that the FTC is considering, which is looking to the Fair Labor Standards Act exemptions for executives or learned professionals, essentially saying that if you're a non-exempt employee, there would be a ban on a non-compete clause applying to you, the non-exempt employee. But if you're an exempt employee, then could be subject to a non-compete clause or subject to this rebuttable presumption on a non-compete clause. Or and also as Jean mentioned, maybe instead of using the exempt non-exempt threshold, do it on a kind of earning threshold. $100,000 per year was one kind of threshold that was identified by the FTC as something they are considering.
And that's what Oregon does in their statute.
Yeah, and again, the FTC also considered, again, referencing some of the laws of the states, including the state of Washington, is saying if you earn above a certain amount, then you can be subject to a non-compete. There would be just not a rebuttable presumption against it, but just you are allowed to be subject to a non-compete. But if you earn less than that, then you could not be subject to a non-compete. That in and of itself we'll have to see how the rule comes out on that in terms of how would you calculate that $100,000? Does that include just wages, or does it include wages plus bonus? Does it include, if you're also an owner, does it include distributions? Does it include benefits, et cetera? So there'd be certainly some additional clarification we need, but the FTC could potentially go that route as well. And then the final alternative would be application of different standards for different types of employees. For example, if you're paid hourly and receive overtime, you're cannot be subject to non-compete. But those who receive a wage, a salary, either as an executive, administrative, or professional employee, then you could be subject to a non-compete. Again, I think the FTC is recognizing that its initial position is very aggressive in that it is a complete and total ban without exception, except for the sale of business. And they are at least, I guess, potentially, hopefully, recognizing that they may need to retrench their position to back off a little bit and give some employers some alternatives in terms of protecting their business interests, protecting their pipelines, protecting their business opportunities through the use of reasonable non-competes to those who are appropriately subject to it, right? I mean, there's a difference between trying to subject to someone who is a hourly worker, a maintenance worker, to a non-compete clause versus subjecting your business development official executive who knows your pipeline, who knows your customers, who deals with your customers. The latter is certainly more appropriate to subject to a non-compete than the former.
And if there is good news, I mean, there is no good news in my mind about this unless you're an employee and you don't want to be subject to a non-compete. But non-competes are one way to deal with this. You can still have a non-solicitation and an NDA that isn't overbroad, that at least gets you 3/4 of the way there. So will it be the end of the world if this ban goes through? It won't be great for a lot of companies that really, train their employees and don't want them to take all of their business contacts with them to a competitor. But at least if you have a provision that says, okay, if you go to a competitor, you can't solicit our clients for a period of time, that isn't going to be banned by this unless it's overbroad. And so that's still something that we can use.
So the final kind of question, then we'll get final slide we have, and then we'll get to some of the questions I've been seeing popping up in the chat, is what are the next steps? Well, there's a deadline of March 20th, 2023 for comments. We put here on the screen how you can comment. There's an online regulations.gov. You just look up the non-compete clause, or for proposed ban on non-compete clause, or that the number there, P201200, and you can submit an online comment. You can do so anonymously if you want to, or you can send it by mail to the Federal Trade Commission, and the address is there. I looked up this morning. Since this was published in January, there have been a total of a little over 13,000 comments received in connection on this proposed rule. There are about 5,300 online comments that were submitted. I certainly haven't read all of them, but I kind of went through a bunch of them, and by far a majority of them that I saw, really all of the ones that I saw, were comments by individual employees in support of the proposed ban. So we can definitely see that there is at least some public support for it. And if you're an employer and you're concerned about it and you want to try to limit the scope of it or push back on it, again, submitting a comment is the appropriate method, appropriate step to take. And so with this, we have about 5 minutes left. So I thought we would kind of go through some of the questions that I think that I saw come up. One question is, how soon might this go into effect? What would be the process for it to happen? Well, so the deadline is March 20th, 23 for comments. So the FTC can't do anything until then. And then after that deadline, the FTC is required to review those comments, and then it will eventually publish what we'll call its final rule, in which it needs to respond to the general categories of comments that are received. We don't know a specific timeline for when that would happen. It could happen this year. If it did so, I would bet it would happen towards the end of this year, because there's just it's a rather lengthy process to go through the rulemaking process and issue your final rule. The FTC needs to kind of consider the comments, draft its response to them, make any changes to the rule, and then submit it to OMB for OMB review before it's finally published as a final rule. And I will also say that I think that if the FTC proceeds certainly with its broad categorical ban on non-competes, when and if it publishes that final rule, it will almost certainly be subject of litigation as employer and employer groups sue the FTC to either argue that it does not have the authority to do so, or that its rulemaking was arbitrary and capricious. Another question is, how about boot camp? I think are you referring to maybe if you're going into the Army or the Navy or the Armed Services and you kind of leave boot camp early? My understanding is the FTC is not going to necessarily apply to the federal government itself, right? The federal government gets to exempt itself from most of the rules that it promulgates that applies to others. So it wouldn't necessarily apply to armed servicemen. Again, this rule on having to reimburse for banning agreements that require employees to reimburse the employer is very broad, but also very vague. It does carve out and say, well, an employer can require an employee to repay the employer for the reasonable expenses incurred by the employer in training them, if there's an agreement to that effect. But it does not provide any definition of what is a reasonable expense, or how is the employer supposed to show that it is a reasonable expense versus having to litigate the issue.
I know we've also been getting a lot of questions on if slides will be available after this webinar, and yes, they will be available on our website for National 8A. I know that's been a question I've been getting a lot, people sending over, so. I know we had one last question come in to our events at email asking, what can small businesses do about the government recruiting your contract employees to GS positions?
So there's not a lot. A lot you can do to contractually prevent them from leaving to work for the government. It's going to be a little bit hard to frame the government as a competitor, I think. Well, I guess in first case, if the proposed ban by the FTC is passed, then there'd be no ability to restrict them. Absent the FTC rule, it would be a subject of state law, and it would really kind of depend on, is the government an actual competitor to you? Most likely not. And so are they going to be really within the realm of the non-compete that would prevent the government from hiring your employees? And I would say, I would think in general, a court would say, well, the government has significant interest in hiring good personnel, and there's going to be a public policy, I would bet, against a rule that would prevent the government from hiring personnel to work for the government.
Great.
Awesome. Well, thank you so much, Chris and Jean, for your time today. They've also included in the slides that'll be posted all their contact information. So if you do have any questions for them, you can reach out to them directly or to our team, and we are happy to put you in contact with them. We appreciate your time today. As I said earlier, the webinar recording and this presentation will be available on our website along with all of our past webinars, hopefully by the end of the day today. We also have some additional resources that will be available at our upcoming events. Definitely save the date for our Alaska Regional Conference coming up this June, as well as our annual golf tournament fundraiser. Those registrations will be opening up at the beginning of March. We also have all of our past conference presentations available on our website. So definitely check those out, including our conference we just had in New Orleans. So definitely check that stuff out as well. And then if you do have any other additional questions, please feel free to reach out to our team. Otherwise, thank you again for joining us today. This concludes today's webinar, and we hope that you'll join us next month. I hope you all have a great day, and that's it.
Thank you all.
Thank you.
See you later.